Legally Speaking with me, Tarun Nangia. Today is an occasion to discuss a very, very special book. This book talks about damages, expert evidence, and valuation in commercial disputes. We all know as India marches ahead from a $2 trillion economy to a $5 trillion one, which will happen surely within the next 3 years. What we are looking forward to are a large number of disputes. Also with a big infrastructure play in India with over $150 being injected in this economy, of course, disputes are a natural fallout. And at this juncture, books like these are very helpful to practitioners of the law. And that's why this effort was undertaken by Senior Advocate Gaurav Pachnanda, who's an advocate practicing at the Supreme Court and also a well-known arbitrator. His co-author Kartikeya Mahajan. We are thankful that Senior Advocate Gaurav Pachnanda joins us today on the show. Good to see you. We also have with us Senior Advocate Darius Khambata, one of country's leading lawyers in the litigation space, also is an eminent name in the field of arbitration. Thank you for joining and encouraging Mr. Pachnanda with your words. Also, your inputs will help us gauge this and assess the coming challenges on the issue of arbitration better in a growing economy. But at the outset, I would want to request Mr. Pachnanda that he gives an opening comment on why this book, because he has a very unique feature in this book. In addition to him and his co-author, many eminent jurists have penned articles. Some of the leading names of Indian legal space. So over to you, Mr. Pachnanda, for your opening comment.
Thank you, Tarun. Thank you very much for inviting me on your show. And thank you, Darius, for making time to be a part of this panel. Tarun, I'll tell you a bit about my journey. A few years ago, nearly years ago, it was Kartikeya's idea who came to meet me. And he was very keen that we explore the issue of damages in some depth and some detail in Indian law. And I think the initial concept was that the two of us will co-author a text. But I think as discussions progressed and as the idea started evolving, what we felt was that the need of a text in India is really with respect to three broad issues. One, of course, is the issue of dividing quantum and liability separately. So damages as to where will the liability lie in the case of breach of contract. And there are principles that govern that. That is one branch of the law of damages. The other was the issue of quantum. Once you have decided liability, what is the manner in which quantification of liability and damages should take place? Those are two broad aspects of damages that we wanted to cover. The second issue was that we wanted an international perspective in this book because we were conscious that there is a small time lag in the sense in which jurisprudence has developed, in the manner in which jurisprudence has developed internationally, because there is a lot of civil trial and civil commercial work happening internationally. And in some sense, our civil trial work is a little overburdened and is a little slow. So the jurisprudence, the speed with which jurisprudence was developing in India and abroad was not the same. So we wanted an international perspective. And the third, of course, was we wanted a practitioner's perspective, not purely an academic perspective. We wanted lawyers who practice commercial law, who come across issues of damages, quantum, liability, how it is done internationally, to have a view and be able to express a practical opinion on issues involved. So it is broadly, we were coming from these three broad principles in our mind, and that is how this book got conceived between me and Kartikeya.
Okay. Thank you for explaining the concept behind the book. I'll go to Mr. Senior Advocate Darius Khambata. Want to know from you how the law has been developing on the issue of damages in the past 10 years and your observations on the same.
Thank you, Tarun. Thank you, Gaurav. Just before I get into that, I'd really like to say that I'm terribly impressed with this book. It fills a much needed niche in the Indian market. As Gaurav rightly put it, our methods of computation of damages in particular, and also the use of expert evidence, have not kept pace with the fast-changing international trends. And I think, given the fact that we are going to be the third largest economy and with the complexity of economic engagements that we already have and will have in the future, it's important to have an effective dispute resolution mechanism in place so that investors, both domestic and foreign, are assured that if the deal goes sour, they do have an effective and quick remedy. We are moving towards that, and books like this help us to move towards that. This ties in really with the answer to your question as well, Tarun. Indian law of damages has not developed as rapidly as international law, but it has developed. It's that it's not set in granite, and I think we've already moved far away from the guesstimate approach that one judgment spoke of. We've also moved away from the old approach that damages are purely mathematically to be computed. In the case of breach of contract, for example, between the date of the breach and the date on which you would have been able to encash your property in. We now have accepted a more international trend of using that old-fashioned approach. In other words, the outer pocket approach, and damages can't exceed that, to a more modern, nuanced approach that you start, that's perhaps a starting point, but you do take into account subsequent events and all the other events and circumstances that affect damages, so as to place the innocent party in exactly the same position as it would have been had there not been a breach. That's a very effective, proactive approach. Our Supreme Court has already recognized that approach. And I'm confident in the future you will have many more decisions nuancing that approach. So yes, we have developed, perhaps not as fast as we might have wanted, but as Gaurav said, there are so many pressing issues on the dockets of courts that it's unfair to expect that they would come up to speed so quickly. But I think courts have recognized that damages and specific performance are a very critical factor in our economy and in the development of our laws. And they're cognizant of that, and they're really coming up to that mark.
Okay, thank you for sharing your opinion on the developing issue of damages in the past 10 years. We will go to Senior Advocate Gaurav Pachnanda on the issue of special Indian treatment on the law of damages. Do you see any difference between law in India and other jurisdictions and your experience? Because you tend to do a lot of international arbitration. And in that view also, if you would share your opinion with us.
Thank you, Tarun. I think the need for a special treatment in a textbook or in a book of the law of damages in India really arises, as the Rais also indicated, because of the lack of breadth of the jurisprudence that we have in India. The depth of jurisprudence is excellent. Wherever these issues have come up, the issues have been very well analyzed in a manner that is internationally respected in Indian jurisprudence. I think the problem area was that there is only so much that comes up to our higher courts on the issue of damages, because the civil trial system generally is clogged and is overburdened. I'll give you an example. There are some 18 or 19 illustrations under Section 73 of the Contract Act that explain how damages are to be ascertained, what are the principles of liability, and what are the principles of application of quantum. But if you really start searching, and you will find that you will not find a judgment on each of those illustrations or explaining the application of those illustrations because of the problem which is typical of our jurisdiction. And as practitioners, the Rais would agree, often whenever we come up with typical situations where there is some absence of Indian jurisprudence, we then end up relying on foreign jurisprudence in international tribunals, sometimes English, sometimes Singapore. And what struck me was that while recognizing the analysis in English judgments, Singapore courts, for example, have evolved their own jurisprudence which caters to the understanding of commercial law principles in Singapore. And that is also typically what Indian courts had been doing. And I just felt that that this book could could help us, first of all, bring that kind of an approach to the forefront. To the extent that principles followed by other courts in other jurisdictions are relevant in India, authors could opine that, as per their understanding, there are X, Y, Z reasons why they should be followed in India. To the extent that authors are of the view that those principles need to be modified or need to be rejected in the Indian context, I felt that practitioners could explain their reasons with a fair bit of analysis, so that ultimately, with the benefit of this kind of a text, ultimately when these principles or these arguments or these propositions reach courts, who will ultimately have the final view on the application of these principles that are followed internationally, some of which are followed internationally, to Indian law, there is some assistance in the form of this book and the views of authors. Of course, finally, what is the correct Indian law with respect to application of those principles will have to be determined by courts. So, but from an academic perspective, from a practitioner's perspective, I thought that it would be a good idea to sort of spread it on the table as to what principles are applicable in India, should be applicable in India, and could be applicable in India. Indian law is not very different in the sense that there's a lot of overlap in common law jurisdictions, but yet there are typical issues that are typical, peculiar to each jurisdiction. And I think in that sense, Indian law is not very different, because most common law jurisdictions would follow some broad principles and yet have their own jurisdiction-specific principles.
Point well taken. I'll go to Senior Advocate Darius Kambata. One thing I would like to know from you: there's no dedicated book on the issue of expert evidence, and for it to be now treated as a distinct branch of law, should we actually have a separate set of books that show and in a sense speak about this issue, so that distinction begins? But first of all, is there really a need to have a distinction that expert evidence is a separate branch of law? And your observations on how this has been happening in India?
This actually raises a very important question, and therein lies some of the value of this book. We often tend to practice very theoretically, and we ignore the practical side of things. But the advantage of this book is it's got practitioners who are at the cutting edge of their trade today, practicing in international arbitration and Indian arbitration, who are able to share their experiences as well as their views on the state of the law. Now, expert evidence is something that was not much known of, say, 20 or 30 years ago in a purely domestic arbitration, especially in terms of quantification of damages. I remember we used to try and work out principles ourselves, pick up McGregor, a book like that, and try and work out what the damages should be. And our client's witness would then go into the box and provide the supporting material. But all that has now changed, because quantification is really now an expert task. Some areas border on econometrics. You have complex formulae. You have different principles for different types of damages. This is really an area where experts have to come in. And you will find now, even in domestic arbitration, there is a huge use of experts. In fact, any complex damages claim will have a battle of experts on both sides. I don't see any large claim going in without experts. So if that's the position now on the ground, it's important to have a treatise that explains what expert evidence is, how to handle it, what are the areas where you can utilize it, and things like that. There are many things that, again, we need a little catching up on. For example, the very commonplace practice abroad of hot tubbing. Many Indian lawyers wouldn't even know the meaning of that expression. But hot tubbing simply means this, that if you have two or more independent experts on both sides, then it's fair to the tribunal to get the distilled product of their expertise. In other words, what are the areas of agreement, what are the areas of disagreement, and what are their different perspectives on those areas of disagreement. And it's found that it's useful to a tribunal to have the experts sit in and give their evidence together, as it were. And questions are put to each expert in the presence of the other, each expert comments on the other's answers, because it is expected, although I confess it doesn't always happen, it's expected that the experts are independent of their clients and want to apprise the tribunal of the best and most correct path forward. And I find hot tubbing does work because it really reduces the areas of controversy and it explains the matter technically in a simple form, not only to the tribunal but to the respective lawyers. So the scope of arguments is more focused, it's narrow. And therefore, there is need to treat expert evidence now as its own branch of evidence. And certainly in the question of damages, a very important aspect of evidence.
Thank you for that comment. Now we come to the issue of quantum of damages. Leading arbitrator who also served as a judge on the Supreme Court once joked with me that Tarun, let me give the damage expert a figure and he'll automatically calculate what has to be calculated and give me that exact figure of damages. So he says, I'm very skeptical when experts come up with figures because they could draw up a list and then come to the figure that was initially given. But be that as it may, what I would like to ask senior advocate Gaurav Pashtanda that he's dealt with this issue in the part 3 of his book. In making or making a case, what do these assessments of quantum of damages have an impact? And also, if you could deal with the issue of skepticism that many arbitrators in India, because we're speaking of Indian jurisdiction, may have on that aspect.
Yes, Tarun, I think that is a very important aspect of the whole bundle of issues that this book deals with. In addition to the reasons explained by Darius, when I started working on this, on the part of this book that dealt with expert damages and quantum, I started from a point where I thought to myself that experts' evidence being tendered in arbitrations, both in domestic and international arbitrations in India, is a reality now. So the experts were here. Some of the best professional expert organizations that help you with quantum all over the world have a presence here. The trend has picked up. In reality, expert evidence provides great assistance to a lawyer who does not have to then sit down and advise on evidence with respect to quantification, because there's a specialist who will look at all the materials before the tribunal and carry out an extensive exercise of expressing a view on evidence. So these two things, in some sense, had already entered the market and had very much become a reality. But the skepticism that you mentioned of one learned arbitrator was also a reality, because what are the principles that the expert has followed in terms of reaching a particular conclusion? There was not adequate familiarity amongst professionals. Where could the expert have gone wrong, and where should an expert be cross-examined? Again, we needed, all Indian practitioners would have felt the need for some guidance. Where can you instruct the expert to not cross the line in terms of giving evidence if you're a junior counsel assisting on a matter? Again, gray area in the context of the Indian market. So I thought that the section that we deal with in expert evidence on quantum would be able to assist arbitrators and judges to test expert reports on at least as a starting point for testing the expert reports when they are before them. The book could also assist practitioners who challenge the expert evidence during trial, because what are the principles based upon which the expert evidence should have been tendered, and where has the expert tried to stretch the envelope? These are very technical matters, and a pure practitioner who's only familiar with the law may not always be in a position to understand. So these were the two issues that I thought that we should assist our colleagues and other participants, players in the profession with. And that is what brought us to deal with expert evidence as a separate section of this book. And what we thought would be a very good idea is to invite some of the leading experts in the Indian market to express their view in chapters that have a lawyer, for example, as a co-author with them. So there is a view that is a blend of an expert's view coupled with a practitioner's view that is presented in a very distilled form. And I think that as a starting point to begin with, I'm very pleased with the effort that we put in and the manner in which it has come out, because I'm just generally getting a sense that it is of good assistance to practitioners in commercial litigation. My experience with quantum assessments, I think two of my most recent experiences, which reinforced my belief that something of this nature should be available to Indian practitioners, is two India-related Indian law arbitrations before international arbitral tribunals. There was a public sector undertaking in one. It was a pure private dispute in the other. In one, and I can't, for reasons of confidentiality, I can't tell you more than what I've just said. In one, I just discovered that the party that succeeded on the issue of liability, and there was an interim partial award by the International Tribunal saying that there was a breach of contract by the other side, could not bring forward the best evidence to prove its damages. And I saw that despite a very clear, unequivocal case on liability, the tribunal awarded, I think, no more than 1,000 rupees as damages to the succeeding party. And that was a case very recently that I saw, which was a classic case of a good lawyer proving on convincing a tribunal, persuading a tribunal on a matter of law that there was a breach, but not being able to bring forward the best evidence to prove the quantum. And then there was this another arbitration recently, international arbitration between two private parties, where I as a matter of fact, again, the tribunal found in favor of one party on the issue of liability, said that the other party had breached the contract. The party had also brought forward very good expert evidence to prove its quantum. But from the award, I discovered that during cross-examination, such serious doubts regarding the robustness and quality of expert evidence were raised, that again, the International Tribunal felt that although reasonably good evidence was brought forward, but it was still unreliable. And again, some $400 or $500 were awarded as nominal damages. And I think these two cases came up during the time when I was putting together this book. And they really reinforced my belief that something of this nature should be available to Indian practitioners for assistance.
Thank you, Mr. Pashnanda, for sharing these two anecdotes. I always say on my show that anecdotes are very useful in understanding an issue, and the more anecdotes you share, the better for viewers. I'll go to Senior Advocate Darius Kapata. In your view, what factors the general counsels and lawyers should keep in mind when they are instructing experts on the issue of quantum damages?
Again, my answer to this really stems out of the previous discussion. You are absolutely right. There is a healthy skepticism of experts in tribunal. Indeed, that's how it should be. And therefore, the expert really should be instructed to provide a rationale to the tribunal rather than just complex figures. Because, as you rightly say, it's always possible to reverse engineer a quantum solution. By saying, well, I want to reach this figure and I'll pull a couple of things out of the hat, a couple of formulas and principles and get to that. That doesn't cut much ice with a good tribunal in any case. So the way you would instruct your expert is give a rationale, give a principled argument to the tribunal to convince it that this is the correct and appropriate way to quantify damages in this case. That is the key to the battle between the experts. And yes, you will have perhaps an equally rational argument on the other side from the opposite party's expert. And therefore, hot tubbing or an evaluation of these competing principles is what a trained legal mind or a tribunal has to evaluate. It's important when instructing experts, therefore, not to let them get into jargonization. I find there's a lot of jargonization because the attempt sometimes is to obscure what you're really doing. And often when I'm in conference, I know there's a lot of jargon spun around, and for the first 10 or 15 minutes, everyone is nodding very wisely around the table because no one wants to admit that they don't understand a word of what's going on. And I'm usually the first to put up his hand and say, I'm sorry, I haven't followed a word. Let's understand what you're saying. And when you break it down, actually, often you find that it's a simple, straightforward principle, which has much more impact when it's shorn of the jargon. And sometimes, in fact, the principle is erroneous because it's masked in jargon. So that sort of input is what a lawyer or a good general counsel should give to his expert, saying, you have to persuade by making a good argument and backing it up with your expertise, rather than by trying to shock and awe, by coming out with a flurry of facts, informations, graphs, and jargon, and hoping that everyone gets a little put off by all of that and steps back and says, well, he is an expert, he must know what he's saying. I don't understand a word of it, but it must be true. That doesn't work. Any good tribunal, that never works. And I've had a case in the past where we had experts on both sides, and the arbitral tribunal said, well, we don't accept either of the experts, and we devise our own formula, which is also possible. And a good tribunal might devise a good formula to go forward. So simplicity, as always, is the ultimate instruction. It's I think, the ultimate instruction for ourselves as lawyers as well. Our task is to simplify and to clarify, rather than making it complex and optically very impressive, but actually intellectually not impressive.
Point very well taken, Mr. Kambata. I'll go to Senior Advocate Gaurav Vachnanda. Arbitrations have been bringing a lot of innovation in dealing with experts and quantum. How are courts now keeping pace with these developments? Especially because experts in quantum and construction arbitration in India have a very deep link, because these arbitral awards are then in the purview of courts when they take a view on these things. And construction arbitration, in my view, has become very complex in India in the recent years, because for long years we had no activity in construction. Suddenly there is just too much of activity. And then so many different types of arbitrations that have resulted out of it. Your view on this whole issue?
So I will, Tarun, I would like to, I am able to answer this question primarily from the context of Delhi High Court, where the bulk of my commercial practice is. And again, when you look at these issues dealt with by the commercial side of Delhi High Court, there will be two broad categories of cases where these issues have come up. There will be cases where people have attempted to seek setting aside of an award. And in the process of engaging with the challenge, the court would have had to deal with expert evidence, which was either the basis of the award, or was rejected during the award, or was partly accepted, partly not accepted. And the second category would be original side cases, original suits, original actions which are tried before the Delhi High Court. Now, in the first category, with respect to challenge of the challenges to the award, I have seen over the last few years that there is a much greater engagement by the court in terms of testing expert evidence on quantification, in terms of testing expert evidence on methodology for calculation of delay as the basis of award of damages. Something that a few years ago, one would see that these are matters that courts are exploring with a bit of diffidence, or with a bit of, shall I say, with a bit of with a slight challenge, because it was new and had not been evaluated properly. But now, increasingly, I see that when these issues come up in matters of challenge to the awards, there is so much of past experience built up over the last few years that the depth of the analysis and the sharpness of the analysis is excellent. The engagement with the issues is excellent, and almost never have I come across a decision that I would disagree with on a matter where expert evidence has either been accepted or rejected by courts. So that, I think, is a reflection on the evolution or the development of the law and the legal system in terms of understanding expert evidence very quickly in a very short span of a few years. With respect to the original actions like suits that are tried before the Delhi High Court, if you see the new Delhi High Court commercial side rules, you will see that they are all geared up to the kind of procedure that we see in commercial courts internationally. So, for example, Darais mentioned hot tubbing, and Delhi High Court rules provide for hot tubbing, recognize hot tubbing of expert evidence as part of a civil trial in Delhi High Court. Recently, I was personally involved in a case where the Delhi High Court, in a civil trial, conducted the whole trial in court, the assistance of an international real-time transcription agency, and a trial that would ordinarily have taken several years because it is often delegated to a court commissioner and done in parts, was over in about 3 to 4 days. From personal experience, I have come across issues where at the stage of final hearing, where expert evidence has already been led, suddenly the court has felt that there is a matter on expert evidence that needs to be understood a bit more while during the process of final hearing. And the court has recalled the expert and has had a one-on-one engagement with the expert to understand the methodology, or both two experts to understand their methodology. So overall, I think it is a very, very positive development. I'm very, very optimistic about the manner in which courts, at least in Delhi, where I practice predominantly, courts have been dealing with the developments with respect to expert evidence and quantification and proof of damages in commercial disputes.
Okay, thanks for explaining that to us. I know Senior Advocate Darais Khambata. Damages have been covered in this book in depth. In your view, how India is dealing with specific performance as a remedy?
That's a very good question as well, because I remember years ago I was at some international conference and a lawyer asked me, contracts get enforced in India. But quite frankly, I didn't know what he was talking about. I said, of course, we have the Contract Act and we have the Specific Relief Act. And I later realized what he actually meant. We had all the black letter law, but on the ground, did someone get this contract enforced? It's a little chastening to know that in 2015, India was ranked 178th out of 189 countries in contract enforcement. That's a very sobering statistics. We love statistics and numbers, so here's one for you. And that is one of the things that motivated the amendments to the Arbitration Act. And we are now happily somewhere around 63. But these are statistics. We need effective enforcement, because ultimately, every contracting party wants the benefit of his bargain. He's not really satisfied with an intricate award for damages. He wanted that contract performed in the first place. So specific performance must be our primary goal. And towards that end, in 2018, of course, the Specific Relief Act was amended to amend Section 10 and to now make specific performance mandatory, barring the exceptional cases set out in the Act, rather than the old discretionary rule that existed. Again, any investor and any litigant, even broader than an investor, wants a robust mechanism for enforcement. Now, it could be an enforcement of a contract. It could even be an enforcement of an award, whether foreign or domestic. He wants to see the result of that litigation quickly. And that is where I think we have some scope for improvement. Our courts are stepping up to the mark. I was happy to hear what Gaurav just said about the Delhi High Court. And I think you will find, as time goes by, that actually civil courts in India will start borrowing techniques from international arbitration and Indian arbitration. Whereas it was earlier, the flow was the other way around. Arbitrators tended to carry the baggage of civil court practice with them. I am hopeful that now it will be a reverse flow. And as Gaurav said, you will have real-time transcription, which is, I cannot understand why our courts have not embraced this, because it's a no-brainer. It cuts the time by 50 to 70% sometimes in terms of speed. It's far more faithful to the record. It enables evidence to be taken directly in court. And there's so many other techniques that can be adopted by our courts without sacrificing the rigor of civil procedure code to really modernize the way we approach dispute resolution. So specific performance has to be the norm, and damage is just the default model. But yes, I think the broader question is, how do our courts start modernizing themselves and dealing with these techniques so that a litigant has a real chance of a dispute resolution even before courts? You know, to divert a bit, abroad, the biggest rival or competitor to international arbitration is the court system, because the court system is often faster than arbitration and less expensive, of course. In India, it's a no-brainer. If you have a commercial dispute, you have to somehow get into arbitration because there's no real final resolution that you can foresee in a court. So we need to think courts need to become more competitive in terms of their approach and technique.
Thanks for pointing that aspect out. I'll go across to senior advocate Gaurav Pachnanda. Now 70 authors from multiple countries have contributed to your book. What was, first of all, the idea behind getting foreign practitioners in a book on Indian law about damages, expert evidence, and quantum? And secondly, how did you go about convincing them and doing this collaboration?
Arun, I think this is another aspect on which credit is due to my colleague and co-editor, Karthikeya. There was a stage when we started working on this book and I felt a little overwhelmed with the volume that I had taken upon myself and volume of writing that I had taken upon myself. And I think when we sat to plan our work, we just felt that it would be a very good idea to involve authors from various jurisdictions. There are two broad reasons, and I will explain these to you. One, of course, is that there is a misconception in India that commercial arbitration should be confined to a separate commercial bar. Rather than commercial, I think the expression used often in India is an arbitration bar. And I have always held the view, and I'm sure that I would agree, that rather than viewing arbitration as a separate animal entirely, it has to be seen as a small subset of commercial dispute resolution generally. And internationally, what I had discovered based on my experience working across jurisdictions is that the best arbitration lawyers are often the best trial lawyers in commercial courts in that jurisdiction as well. So I saw, first of all, I recognized and I saw that the best talent internationally that was able to contribute or would be in a position to add value to this book would bring in their experience that was not confined to arbitration alone, but was sort of also overlapping in courts, because most of them would have practiced both in commercial courts and in arbitration. And the second, of course, was that I had over the last few years realized that a significant number of important commercial disputes that have an India connection had so much in terms of complexity of issues, complexity of commercial concepts, complexity of technical aspects, that they were not really confined to the sort of knowledge bank that was located in India alone. We were already relying upon foreign law, and I felt that we will it will only be normal that organically we will grow into a form where a lot of the distinctions between these sort of broad chunks of knowledge would get blurred, and we will be able to draw on knowledge across jurisdiction. So I thought this book could be a very good effort to bring across cross-fertilization of ideas on concepts that were relating to damages and their quantification in the Indian context. Because, first of all, disputes were multi-jurisdictional, that gave me a good basis to make the book multi-jurisdictional, yet India-focused, because the book does not specifically always deal with law in Singapore or law in UK, but it deals with law in Singapore on a particular topic and how that could apply to India, law in London on a particular topic and how that could or could not apply in India. So the cross-fertilization between the ideas, concepts, jurisprudence in different jurisdictions was then focused in a manner that we could draw on it as Indian practitioners. So I think so. That was the idea behind getting 70 authors. The practical aspects of getting all of them to make time for this book, and then to sort of make sure that all of their timelines would fit within the timeline that we had for our publisher, was not very challenging. To be very honest, I must say that the idea of this book was accepted and with a lot of enthusiasm by all the contributors. A lot of them felt that they had some component of an India practice in their overall practice, even if they were located in London and Singapore. And they all realized that there was a small gap that could be filled by this book. So I think in practice, in getting them to all put together their ideas was not that difficult. The added advantage of this project was that we were also able to, by bringing together a group of 2 or 3 authors for one particular chapter, we were also able to make introductions between practitioners and individuals. So it is not always that Mr. X, who's a senior advocate in Delhi, who's now writing a chapter with Mr. Y, who's a senior partner in London. It is not always the case that they might have even come across each other or have worked together with each other. So I think in addition to cross-fertilization of ideas for the book, I also believe that it was a very good idea to bring about a group of 70 people for exchange of ideas generally on an academic project that may proliferate or develop into, I don't know how many more ideas in the years ahead.
Point very well taken, and may you have a lot of more ideas and feedback on this book, which will allow you to develop another one. But I'll go to Senior Advocate Darius Khampata. What is your expectation or vision for scholarship in this field going forward on the issue of arbitration? Secondly, on Indian private law, how do you feel the discourse should be structured going forward?
Okay, so that's a huge canvas. So let me try and give a few thoughts. First of all, the book, coming back to the book, I think one of the important things about the book is the fact that you have different thoughts from different jurisdictions all coming and coalescing together in this one place. And this is important because the future of common law is now no longer restricted to England. It's jurisdictions like India, Singapore, Australia, Canada, which will really advance the boundaries of common law, particularly India with its growing economy. And in India, naturally, because of the obvious burdens on our civil court system, that advancement will come in arbitration. And when those matters pertaining to arbitration come up to the courts for scrutiny. So you will expect a lot of development in the law, and we should expect that from our courts. Our courts are very innovative. They're open to ideas and ideas from different jurisdictions. So I think the future here in India will be development of various principles of law, not only just those borrowed from other jurisdictions, but evolved by Indian courts. I think there's a lot of scope for that now, and we can already see it happening, and I think it will only increase in the future. I'm always a great believer in books, and I think a good book put together like this is invaluable as compared to your laptop on which you punch in some query, a query completely fettered by the limits of your own knowledge, and you think you've got the eureka answer when a couple of judgments come up onto your screen. I think there's no substitute for a book like this, the wisdom you get, the ideas you get. And I think as we go forward, a good book coupled with a backdrop is the way to go, rather than just the latter. I was telling Gaurav, in fact, before this, that I hope this book is updated. Now, this is a new concept. When you have a compendium book like this of different articles, it's difficult to get the authors or the same sets of authors to update. As far as possible, it would be good if it's the same authors, but even if it wasn't, it might be an idea to maybe review this book in 5 or 10 years, maybe. 5 years, I think, is a good time frame. I think whether you should add articles to it or to update the existing articles for developments in the law. That's one aspect. My expectation and vision for scholarship is that we lawyers are perpetually students. We never stop being students. The moment any lawyer thinks he knows everything, he's clearly on a slippery slope. The time has come for us Indian lawyers now to also start thinking out of the box. We need to innovate. We need to restructure the way we practice. This has been my favorite theme in many conferences, but I think it's very critical. We need to step up to this challenge. And I have full confidence that we will, because with the expertise we built up over decades of commercial trial court practice, I think it's only a matter of time before the Indian lawyer gets onto the world stage and dominates it. But we need to get our techniques together. We need to get our methods together. So my vision for the future is a leaner, more effective Indian bar, which, as Gaurav said, could be an arbitration bar or a combined bar practicing in courts and arbitrations, because I think that's the way to go.
Point very well taken. And you also said that lawyers try to read a lot. They're always in learning mode. I also think they start to age in reverse after the age of 60. I see lawyers start getting younger after they turn 60. So that is a phrase I picked up from somewhere. But two things that I need to point out. It was a really informing show for the viewers, and we expect to turn a few chapters of Senior Advocate Pashnanda's book into another few shows with varied panelists, which would be useful for the audience which primarily arbitrates in India, but also invests in this country. They look forward to such books. I would especially like to thank Rayas Kambata. He made time at a short notice and joined us for the show. Senior Advocate Gaurav Pashnanda, it was a pleasure having you on the show. I'm sure you would enjoy it as well. Thank you so much.
Thank you.
Thank you very much. Thank you, Rayas. Thank you.